Fraud section 17 of the Indian Code what the definition of fraud under section 17. Fraud means and includes any of the following acts committed by a party to a contract or with his connivance or by his agent with an intent to deceive another party thereto or his agent or to induce him to enter into the contract. The suggestion has effect of that which is not true. Why one who does not believe it to be true. The active con- the active concealment of a fact by one having knowledge or belief of the fact, a promise made without any intention of performing it, any other act fitted to deceive. Any such act or omission has the law especially declared to be fraudulent. The following are essential elements of the fraud. There must be a representation or assertion, and it must be false. However, silence may amount to fraud or unactive concealment may amount to fraud. Whether silence is fraud or not, as per explanation of section 17, silence is fraud in following situations. There is duty to speak. A sell by auction to be a horse which A known to be unsound. A says nothing to B about the unsoundness of the horse. This is not a fraud by A. In the above example, B is A's daughter. Here, the relation between the parties would make it A's duty to tell B if the horse is unsound. Then silence is equal to speech. B says to A, if you do not deny it shall assume that the horse is sound. A says nothing. Here is silence is equivalent to speech. The representation must be related to a fact. A who is about to sell goods says that goods cost him rupees 50,000. This is a statement of fact. But if he says the goods are worth 50,000 rupees, it is a settlement of opinion. The representation should be made before the conclusion of the contract with the intention to induce the other party to act upon it. The representation or statement should be made with a knowledge of its falsity or without belief in its truth or recklessly not caring whether it is true or false. The other party must have been induced to act upon the representation or assertion. A bought shares in a company on the faith of a prospectus which contained an untrue statement that B was a director of the company. A had never heard of B and he had never heard of B, and therefore the statement was immaterial from his point of view. A's claim for damages in this case was diminished because the untrue statement had not induced A to buy the shares. The other party must have relied upon the representation and must have been deceived. The other party, acting on the representation, must have consequently suffered a loss. Effect of fraud upon validity of a contract. When the consent to an agreement is caused by the fraud, the contract is voidable at option of the party uh, defrauded, and he has the following remedies. He can rescind the contract within a reasonable time. He can sue for damages. He can insist on the performance of the contract on the condition that he shall be put in the position in which he would have been had the representation made been true. Exception: in the following cases, contract is not voidable if the party whose consent was caused by silence which amounting to fraud had the means of discovering the truth with ordinary diligence. With ordinary diligence, a fraud which did not cause the consent of the party to agreement. Fourth, misrepresentation, Section 8. According to Section 8 of the Indian Contract Act 1872, there is misrepresentation, statement of fact which is false would constitute misrepresentation if the maker believes it to be true but which is not justified by the information he possesses. When there is a breach of duty by a person without any intention to deceive, which brings an advantage to him, then a party causes even tough done innocently the other party to the agreement to make a mistake as to the subject matter. A makes a positive statement to B that she will be made the director of a company. A makes the statement on information delivered not directly from C but from M. B applies for shares on the faith of the statement which turns out to be false. The statement amounts to misrepresentation because the information received second hand did not warrant A to make the positive statement to B. A believed the engine of his motorcycle to be in an excellent condition. A without getting it cracked in a workshop, told to B that the motorcycle was in excellent condition. On this statement, bought the motorcycle whose engine provide to be defective. Here is statement is misrepresentation as the statement turns out to be false. A will selling his mare to B tells him that the mare is sound, roughly sound. I geniusly believe the mare to be sound, although he has no sufficient ground for the belief. Later on, B finds the mare to be unsound. The representation made by A is a misrepresentation. A by an article thinking that it is worth 1000 rupees when in fact it is worth only 500 rupees. There has been no misrepresentation on the part of the seller. The contract is valid. Difference between coercion and undue influence. Basis of difference. Nature of action. It involves the physical force of threat. The aggrieved party is compelled to make the contract against its will. Undue influence. It involves moral or mental pressure. Involvement of criminal action. Coercion. It involves committing or threatening to commit and act forbidden by Indian Penal Code or detaining or detaining to detain property unlawfully. No such illegal act is committed or a threat is given. Relationship between parties. It is not necessary that there must be some sort of relationship between the parties. Some sort of relationship between the parties is absolutely necessary. Exercised by whom? Coercion need not proceed from the promiser, nor need it be the directed against the promiser. It can be used even by a stranger to a contract. Undue influence is always exercised between the parties to a contract. Enforceability. The contract is voidable at the option of the party whose consent has been obtained by the coercion, where the consent is undue by induced by undue influence. The contract is either voidable or the court may set it aside or enforce it in a modified form. Position of benefit received. In case of coercion, where the contract is resigned by the aggrieved party, as per section 64 of the Indian Contract Act, any benefit received has to be restored back to the other party. The court has the discretion to direct the aggrieved party to return the benefit in whole or in part, or not to give any such directions. Distinction between fraud and misrepresentation. Basis of difference. Fraud, misrepresentation. Intention to deceive the other party, hiding the truth. Misrepresentation. There is no such intention to deceive the other party. Knowledge of truth. The person making the suggestion believes that the statement is untrue. The person making the statement believes it to be true, although it is not true. Rescission of the contract and claim for damages. The injured party can repudiate the contract and claim damages. The injured party is entitled to repudiate the contract or sue for restitution, but cannot claim the damages. Means to discover the truth. The party using the fraudulent act cannot secure or protect himself by saying that the injured party had means to discover the truth. party can always pledge, always plead that the injured party had the means to discover the truth. Mistake of law, mistake of Indian law, mistake of foreign law, mistake of fact, bilateral mistake, unilateral mistake. Bilateral mistake में mistake has to subject matter, mistake has to possibility of performance. Mistake has to subject matter, quality, existence, identity, title, price, quantity. Mistake has to possibility of performance, legal or physical. A unilateral mistake of fact, identity of person, character of written document. Mistake may be defined as inconsent or erroneous belief which leads the party to misunderstand the others. Mistake may be either mistake of law or mistake of fact. Mistake of law. Mistake of law is further classified as mistake of Indian law or mistake of foreign law. Mistake of Indian law. A person cannot be allowed to get any relief on the ground that it had done a particular act in ignorance of law. A and B enter into a contract on the erroneous belief that a particular debt is barred by the Indian law of limitation. It is correct. It is correct. Is not voidable. It is this contract is not voidable. Mistake of foreign law. Such a mistake is treated as mistake of fact that and the agreement in such a case is void. Mistake of fact. Mistake mistake of fact are of two types: bilateral mistake, unilateral mistake. Bilateral mistake, where the both parties to an agreement are under a mistake as to a matter of fact essential to the agreement. There is a bilateral mistake. In such a the agreement is void. Section 20. Cases of bilateral mistake. Mistake has to the quality of the subject matter. Mistake has to the existence of the subject matter. Mistake has to the identity of the subject matter. Mistake has to the title of the subject matter. Mistake has to the price of the subject matter. Mistake has the quantity of the subject matter. Unilateral mistake. According to section 22 of the Indian Contract 1872, a contract is not voidable merely because it was caused by one of the party to it being under the mistake as to a matter of fact. Legality of object and consideration. Which consideration and objects are lawful and those which are not. Section 23. Under section 23 of the Indian Contract 1872, in each of the following cases the consideration or object of an agreement is said to be unlawful: when consideration or object is forbidden by law. Acts forbidden by law are those which are punishable under any statute, as well as those prohibited by regulations or orders made in exercise of the authority conferred by the legislature. A father had arranged for marriage of his 17 years boy and took dowry from the girl's parents. Such marriage contract cannot take place as in India. And the minimum age for boy marriage is 21 years and dowry is not permissible in Indian law. Such in such is not a valid contract as the consideration and object both are forbidden by law. When consideration or object are of such a nature that if permitted it would defect the provisions of law. If the consideration or the object of an agreement is of such a nature that not directly but indirectly it would but indirectly it would defeat the provisions of the law. The agreement is void. The agreement is void. Is state is sold for arises of revenue under the provision of an act of the legislature by which the defaulter is prohibited from purchasing the estate. B. Upon an understanding with A becomes the purchaser and agrees to convey the estate to A. Upon receiving from him the price which B has paid, the agreement is void, as it renders the transaction in effect a purchase by the defaulter, and would so defeat the object of the law. When it is fraudulent, agreements which are entered into to promote fraud are void. A, B, and C enter into an agreement for the division among them of gains acquired or to be acquired by them by fraud. The agreement is void, has its object with equation of gains by fraud is unlawful. The general term injury means criminal or wrongful harm. In the following examples, the object or consideration is unlawful as it involves injury to the person or the property of another. An agreement to print a book in violation of another's copyright is void. As the object is to cause injury to the property of another, it is also void as the object of the agreement is forbidden by the law relating to copyright. A promises to repay his debt by doing manual labor daily for a special period and agree to pay interest at an exorbitant rate in case of default. Here is promised to reply by manual labor is the consideration for the loan, and this consideration is illegal as it imposes what in substance amounts to slavery on the part of A. In other words, has the consideration involves injury to the party to the person A, the consideration is illegal. Here the object here the object to is illegal. Has it seeks to impose slavery, which is opposed to public policy. Hence, the agreement is void. Then, consideration is immoral. The following are the examples of agreements where the object of consideration is unlawful, being immoral. Where P had advanced money to D, a married woman, a married woman to enable her to obtain a divorce from her husband, and D had agreed to marry him as soon as she could obtain the divorce. It was held that P was not entitled to recover the amount, since the agreement had for its object the divorce of D from her husband, and the promise of marriage given under these circumstances was against good morals. A asks B, if you arrange a girl for marriage with me, eh, I will give rupees 50,000 rupees. Here wanted is void, as it is immoral. When consideration is opposed to public policy, the expression public policy can be interpreted either in a wide or in a narrow sense. The freedom to contract may becomes may become illusory unless the scope of public policy is restricted. In the name of public policy, freedom of contract is restricted by by law only for the good from the community. Some of the agreements which are held to be opposed to public policy are trading with enemy and trading any trade with person owing allegiance allegiance to a government at war with India without the license of the government of India is void. As the object is opposed to public policy, here the agreement to trade of offense against the public policy by tending to prejudice the interest of the state in times of war. India entered in war-like situation with China. Mr. A from India entered into contract with China for import of toys. Such contract is void as China is allied enemy of India. The contract, if made before such war-like situation, may be suspended or dissolved. Like India felt apps like TikTok and PUBG will provide some internal information of the country. Hence, such apps were banned, and any contract with them were dissolved. dissolved. Shifting, shifting, shifting shifting prosecution, an agreement to certify prosecution, that is an agreement to present proceeding already instituted from running their normal course using force tends to be a perversion or an abuse of uh, abuse of justice. Therefore, such an agreement is void. The principle is that one should not make a trade of felony. The compromise of any public offences is generally illegal. And under the Indian Criminal Procedure Code, there is, however, a statutory list of compoundable offences and an agreement to drop proceeding relating to such offences with or without permission of the court. Has the case may be in consideration, the accused promising to do something for the complainant is not opposed to public policy. Thus, where A agrees to sell certain land to B in consideration of B sustaining from taking criminal proceeding against A with respect to an offence which is compoundable. The agreement is not opposed to public policy, but it is other but it is otherwise if the offence is uncompoundable. Maintenance and maintenance and champerty. Maintenance is an agreement in which a person promises to maintain suit in which he has no interest. A offer B rupees 2000 if he sues C for a case which they could have settled mutually under provisions of law. Just to annoy C, such agreement is maintenance agreement. Champerty is an agreement in which a person agrees to assets another in litigation in exchange of a promise to hand over a portion of the proceeds of the action. A agrees to pay expenses to B if he sues C and B agrees to pay half of the amount received from result of such suit. This is an agreement of champerty. The agreement for supplying funds by way of maintenance or champerty is valid unless it is unreasonable so as to be injustice to other party, or it is made by a malicious motive like that of gambling in litigation or uh, appeasing other party by encouraging encouraging unrighteous suits and not with the bona fide object of assisting a claim believed to be just. Trafficking relating to public offices and titles. An agreement to trafficking in public office is opposed to public policy, as it interferes interferes with the appointment of a person best qualified for the service of the public. Public policy requires that there should be no money consideration for the appointment to an office in which the public is interested. The following are the example of agreements that are void since they are tenant amount to sale of public offices. An agreement to pay money to a public servant in order to induce him to retire from his office so that another person may secure the appointment is void. An agreement to procure a public recognition like Padma Vibhushan for reward is void. Harris paid 15,000 rupees to the officer to give his son the job in the Forest Department of India. On on failure by officer he could not recover the amount as such contract amounts to trafficking in public office which is opposed to public policy. Agreements tending to create monopolies, agreements having for their object the establishment of monopolies are opposed to public policy and therefore void. XYZ and ABC were only the manufacturers of oxygen cylinders in West Bengal. They both entered into contract of supplying the same at very high rates and enjoy the monopoly rates during the COVID period in the country. Such contract is opposed to public policy as they intended to create monopolies. Marriage brokerage agreements. An agreement to negotiate marriage for reward which is known as a marriage brokerage contract is void as it is opposed to public policy. For instance, an agreement to pay money to a person hired to procure a wife is opposed to public policy and therefore void. Note: Marriage Bureau only provides information and does not negotiate marriage for reward. Therefore, it is not covered under this point. Interference with the course of justice. An agreement whose object is to induce any judicial officer of the state to act partially or corruptly is void, as it is opposed to public policy. So also is an agreement by A to reward B, who is unintended witness in a suit against A in consideration of B's absenting himself from the trial for the same reasons. An agreement which contemplates the use of underhand means to influence legislation is void. Interest against obligation. The following are examples of agreement that are void has been tend to create an interest against obligation. The object of such agreements is opposed to public policy. An agreement is an agreement by an agent to receive without his principal's consent compensation from another for the performance of his agency is invalid. A uh, who is the manager of a firm agrees to pass a contract to X if X pays to A rupees 2 lakhs privately, the agreement is void. Consideration unlawful is in part by virtue of section 24 of the Indian Contract Act 1872 if any part of a single consideration for one or more objects or any one or any part of any of several considerations for a single object is unlawful, the agreement is void. This section is an obvious consequence of the general principle of section 23 of the Indian Contract Act 1872. There is no promise for a law consideration if there is anything illegal. It is a consideration which must be taken as a whole. The general rule is that where the legal part of a contract can be served from the illegal part, the bad part may be rejected and the good one can be retained. But where the illegal part cannot be served, the contract is altogether void. Void agreements expressly declared to be void agreements made by incompatibility of the parties. Section 11 of the Indian Contract Act 1872. Agreements made under bilateral mistake of fact. Section 20 of the Indian Contract Act 1872. Agreements the consideration or object of which is unlawful. Section 23 of the Indian Contract Act 1872. Agreement the consideration or object of which is unlawful in parts. Section 24 of the Indian Contract Act 1872. Agreements made without consideration. Section 25 of the Indian Contract Act 1872. Agreement in restraint of marriage. Section 26 of the Indian Contract Act 1872. Agreement in restraint of trade. Section 27 of the Indian Contract Act 1872. Agreement in restraint of legal proceeding. Section 28 of the Indian Contract Act 1872. Agreement the meaning of which is uncertain. Section 29 of the Indian Contract Act 1872. Wagering agreement. Section 30 of the Indian Contract Act 1872. Agreement to do impossible acts. Section 56 of the Indian Contract Act 1872. Agreement is in restraint of marriage. Section 26 of the Indian Contract Act 1872. Every agreement in restraint of marriage of any person other than a minor is void. So if a person being a major agrees for goods consideration not to marry, the promise is not binding and considered as void agreement. Agreement in restraint of trade. Section 27 of the Indian Contract Act 1872. An agreement by which any person is restrained from exercising a lawful profession, trade or business of any kind is to that extent void, but this rule is subject to the following exceptions, namely where a person sells the goodwill of a business and agrees with the buyer to refrain from carrying on a similar business within specified local limits, so long as the buyer on his successor in interest careers on a like businesses therein. Such an agreement is valid. Goodwill is the advantage enjoyed by a business on account of public uh, patronage and encouragement from habitual customers. The local limits within which the seller of the goodwill agrees not to carry on similar business must be reasonable. Under Section 36 of the Indian Partnership Act 1932, if an outgoing partner makes an agreement with the continuing partners that he will not carry on any business similar to that of the firm within a specified period or within specified local limits, such an agreement thought to restrain of trade will be valid if the restrictions imposed are reasonable. Similarly, under Section 11 of the Indian Code of 1870, an agreement between partners not to carry on competing businesses during the continuance of partnership is valid, but an agreement of service by which an employee binds himself during the term of his agreement not to compete with his employer is not in restraint of trade. B. A physician and surgeon employs A has an assistant for a term of 3 years and A agrees not to practice as a surgeon and physician during these 3 years. The agreement is valid and A can be restrained by an injunction if he starts independent practice during this period. An agreement by a manufacturer to sell during a certain period his entire production to a wholesale merchant is not in restraint of trade. Agreement among the sellers of a particular commodity not to sell the commodity for less than a fixed price to maintain the quality of the product is not an agreement in restraint of trade. An agreement in restraint of legal proceeding. Section 28 of the Indian Contract Act 1872. An agreement in restraint of legal proceeding is the one by which any party thereto is restricted absolutely from enforcing his rights under a contract through a court or which abridges abridges the usual period for starting legal proceedings. A contract of this nature is void. However, there are certain exceptions to the above rule. A contract by which the parties agree that any dispute between them in respect of any subject shall be referred to arbitration, and that only the amount awarded in such arbitration shall be recoverable is a valid contract. Similarly, a contract by which the parties agree to refer to arbitration any portion between them which has already arisen or which may arise in future is valid, but such a contract must be in writing. Agreement, the meaning of which is uncertain. Section 29 of the Indian Contract 1872. An agreement, the meaning of which is not certain, is void, but where the meaning thereof is capable of being made certain, the agreement is valid. A agrees to sell B 100 tons of oil. There is nothing whatever to show what kind of oil was intended. The agreement is void for uncertainty, but the agreement would be valid if A was the dealer only in coconut oil, because in such a case its meaning would be capable of being made made certain. Wagering agreement. Section 30 of the Indian Contract Act of an agreement by way of a wager is void. It is an agreement involving payment of a sum money upon the determination of an uncertain event. Is essence of a wager is that each side should stand to win or lose depending on the way an uncertain event takes place, in reference to which the change is taken, and in the occurrence of which neither of the parties has legis- legitimate interest. A agrees to pay 50,000 rupees to B if it rains, and B promises to pay a like amount to A if it does not rain. The agreement will be by way for wager, but if one of the parties has control over the event, agreement is not a wager. Essential of a wager, there must be a promise to pay money or money's worth. Promise must be conditional on an event happening or not happening. There must be uncertainty of event. There must be two parties. Each party must stand to win or lose. There must be common intention to bet at the timing of making such agreement. Parties should have no interest in the event except for stake. Transactions similar to wager, gambling. Lottery transactions. A lottery is a game of chance and not of skill or knowledge. Where the prime motive of participant is gambling. The transaction amount to a wager, even if the lottery is sanctioned sanctioned by the government of India. It is a wager transaction. The only effect of such sanction is that the person reasonable for running the lottery will not be punished under the Indian Penal Code. Lotteries are illegal and even collateral transactions to it are tainted with illegality. Section 294A of Indian Penal Code. Crossword puzzles and competitions. Crossword puzzles in which prizes depends upon the correspondence of the competitor's solution with a previously prepared solution kept with the editor of a newspaper is a lottery and therefore a wagering transaction. Case law, State of Bombay versus RMD, Chamber Bangwala AIR 1957. Facts: A crossword puzzle was given in many magazine. Above mentioned clause was stated in the magazine. A solved his crossword puzzle and his solution corresponded with previously prepared solution kept with the editor. Held this was a game of change and therefore a lottery wagering transaction. Crossword puzzles, picture competitions and athletic competitions where prizes are awarded on the basis of skill and intelligence are the games of skill and hence such competitions are valid. According to the Prize Competition Act 1955, prize competitions in games of skill are not wagers provided the prize money does not exceed rupees 1000. Speculative transactions, an agreement or a share market transaction where the parties intend to settle the difference between the contract price and the market price of certain goods or shares on a specified day is a gambling and hence void. Horse race transactions, a horse race competition where prize payable to the bet winner is less than 500 is a wager. A and B enter into an agreement in which A promises to pay 2 lakh rupees provided Chetak wins the horse race competition. This is not a wagering transaction. However, Section 30 is not applicable in an agreement is to contribute toward plate price or sum of money of the value of 500 rupees or the above to be awarded to the winner of a horse race. Transactions resembling with wagering transaction but are not void. Chit fund. Chit fund does not come within the scope of wager. Section 30 of the Indian Contract address bata. In case of a chit fund, a certain number of persons decide to contribute a fixed sum for a specified period, and at the end of a month the amount so contributed is paid to the lucky winner of the lucky draw. Commercially transactions or share market transactions. In this transaction, in which delivery of goods or shares is intended to be given or taken, do not amount to wagers. Games of skill and athletic competition, crossword puzzles, picture competitions, and athletic competitions where prizes are awarded on the basis of skill and intelligence, or are the games of skill, and hence such competition are valid. According to the Prize Competition Act 1955, prize competition in games of skill are not wagers, provided the prize money does not exceed rupees 1000. A contract of insurance. A contract of insurance is a type of contingent contract, is valid under law, and these contracts are different from wagering agreements. Distinction between contract of insurance and contract of wagering agreements, meaning it is a contract to indemnify the loss. Wagering agreement, it is a promise to pay money or money bought on the happening or non-happening of an uncertain event. Consideration. The crux of insurance contract is the mutual consideration, premium and compensation amount. There is no consideration between the two parties. There is just gambling for money. Insurable interest. In insured party has insurable interest in the life or property sought to be insured. The wagering agreement. There is no property in case of wagering agreement. There is betting on others' life and properties. Contract of indemnity. Except life insurance, the contract of insurance indemnifies the insured person against loss. Loser has to pay the fixed amount on the happening of uncertain event. Enforceability. It is valid and enforceable. It is void and unenforceable agreement. Premium. Calculation of premium is based on scientific and actuarial calculation of risks. No such Logical calculations are required in case of wagering agreement. Public welfare. They are beneficial to the society. They have been regarded as against the public welfare. Descriptive questions. An agreement the meaning of which is not certain is void discuss. Agreement the meaning of which is uncertain. Section 29 of the Indian Contract 1877.